from a man facing charges for repeated assaults and blatant disregard for protective orders.
Victim stated that the suspect took their daughter's phone. Victim stated that when she attempted to get the phone back, the suspect struck her in the right side of the head one time with his hand. Victim had 2 visible bumps near the right temple. So, explain.
To another back in court for violating probation.
In the past, have you ever used any type of drugs? All right, and what would that be?
Let's watch Judge Boyd handle these cases with no tolerance for excuses, starting with Mr. Javon, who repeatedly assaulted his partner and violated protective orders, now back in court, hoping to walk free after serving time, which is crazy.
Court is calling 2024 CR 0572, State of Texas versus Javon Allen Amore. Could I have parties announced for the state?
Ashley Jones.
Defense.
Peter Calderola, standing in for Gail Calderola for Mr. Amore, Your Honor.
And are you Mr. Amore?
Yes, ma'am.
All right, do you have any objections to this attorney standing in? All right, counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find the state is in compliance with discovery. Mr. Amore, did you review the true bill of indictment with your attorney? Did you understand it?
I have, Your Honor. Yes, I understand.
Counsel, do you waive the reading of the indictment?
Yes, Judge, we do.
State, are you proceeding on the indictment as presented? All right, Mr. Amore, did you review the document entitled?
We did indictment to correct the date, the year, and
Thank you, Judge.
paragraph 2023.
All right, any objection to the state
No objection, Your Honor.
amending the indictment or correcting the indictment?
None, Judge.
All right, Mr. Moore, do you understand that's a substantive change to the indictment?
I understand.
And knowing that, do you still wish to proceed?
I understand you.
And do you waive the time your counsel has to prepare for trial? Your counsel has 10 days to prepare for
Oh,
trial.
yes.
Are you waiving that?
Yes.
Do you wish to proceed?
Yes. Yes.
All right, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with assault family household member with a previous conviction as a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Moore, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a cap of 4 years in the prison. There's a $1,500 fine and no applications. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor. I understand.
Knowing that, do you still, do you understand that to be the entirety of your plea?
Yes, Your Honor.
Defense is at the plea?
It is, Judge.
State is at the plea?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I have signed another incorporation, Your Honor.
Did you understand by signing that you're waiving your right to only items that can be appealed or written pretrial motions that have been filed, heard, and ruled upon by the court? Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
None, Judge. None that I'm aware of.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
Yes, Your Honor. State author states in Exhibit 1 and all attachments.
No objections, Your Honor.
All right, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you asking to proceed with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Yes, Your Honor, whenever the court's ready.
I'm ready.
Thank you, Judge. Your Honor, respectfully, today we'd be requesting 2 years TDC for Mr. Moore. He's been in custody for approximately 418 days. I believe the docket reflects 412, but I understand it was printed several days ago. He's a 36-year-old man, Judge, and he has been with the complainant, Miss Capricia Morris, for approximately 9 years, Judge. Ms. Morris does have 4 children, and Mr. Moore has stepped in as a father for those children. Now, he does not have any paternal rights, but he has helped raise those kids for the last 9 years. Ms. Morris has actually contacted our office as well as my client's mother, requesting that Mr. Moore be home. Mr. Moore is motivated and will be dedicated to finding a job so he can get back to supporting those children. And Ms. Morris as well, Judge. And that's the reason we're asking for the 2 years today, as opposed to anything beyond that.
All right, and what is happening with this violation of bond or protective order?
Your Honor, our understanding is that the complainant does not want to proceed, so the state will be dismissing the complainant.
All right. And then, State, what are you requesting?
Your Honor, the state is requesting 4 years, the 4 years, that's part of the corrections. That does have several arrests for assaults. Unfortunately, those were dismissed for missing witness, but it does seem to be a pattern with this defendant. Additionally, as the court can see here, there are 2 cases in front of the court for assault on the same complainant that the defendant does want to go back to. Sometimes, even though the complainant does not want to proceed, it is the state's job to look out for the safety of that complainant and the safety of our community. So for those reasons, the state is asking the defendant to be sentenced to 4 years.
All right, is there anything you wish to say, sir?
I have learned my lesson, Your Honor, and I would like to go home and be with my kids. I love them and support them financially, and would love. I've been here over 400 days, Your Honor, and what I did was while I was here, I signed up for GED, and I just want to go home and take care of my
You signed up for what?
GED.
All right. So here's my question. I read the police report. Why did you hit her?
Allegedly,
Well, no, I mean, I read the stipulations, and according to the stipulations, what it says is, I spoke with the victim who stated that the suspect, that's you, had struck her
Yes.
earlier in the day. The victim stated that the suspect took their daughter's phone. Victim stated that when she attempted to get the phone back, the suspect struck her in the right side of the head 1 time with his hand. Victim had 2 visible bumps near the right temple. So, explain.
I had to be stressed out or going through something, Your Honor.
So, is this the first time you've ever hit her?
Yes, ma'am.
All right, and what is this violation of protective order about?
I can't be with her. Is that
No. Yes. So let me ask everyone, the violation of protective order, is that offense alleged to have been committed before or after this incident, right? So it appears that you have anger issues. So what were you going through that caused you to hit someone that I'm assuming you love?
probably have to been probably alcohol was involved, Your Honor.
Mhm.
And I don't drink no more. I don't smoke. I don't drink. I don't even smoke cigarettes no more, Your Honor. But my spare time, all I do is read the Bible and learn the good gospel of the word.
This is what the court is going to do. The court is going to find you guilty. The court will give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Capricia, Kaprisha, Lavon Morris. There's a $1,500 fine, time and money to run concurrent, and the court will sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you. We can go off the record. Here's the thing, you can't hit people that you claim to love. You understand?
Yes, Your Honor. I understand.
All right, good luck to you, all right?
Thank you, Your Honor.
You're welcome. Thank you so much.
Thank you.
Your Honor, if we may, Would you consider an application for shock probation if you were to file one?
No.
While Mr. Javon faced the consequences of his violent behavior, Ms. Nutter here is back in court for breaking into someone's home. Her erratic behavior is enough to piss anyone off.
All right, we're back on the record in 2024 CR 011162, State versus Nicole Nutter. If I could have parties reannounced for the record, State. Defense.
Albert Chidas for Ms. Nutter.
And are you Ms. Nutter?
Yes, ma'am.
All right. So, State, you said that you had another witness present.
One other person I was gonna call.
All right, if you call them, please.
Paige Slater.
All right, hello. Hi, and excuse me, you need to stand over there. If you'll raise your right hand for me. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Paige Slater.
All right, if you'll make sure you keep your voice up so that I can hear, because my allergies are acting up, and also so that the court reporter can hear.
Yes.
All right, defense.
Could you let me know what your relationship is to Ms. Nutter?
She's my mom.
And where do you live? Not address, but town?
San Antonio.
Okay. And are you willing to help your mom get through, assuming the court were to give her probation, are you willing to assist her in housing?
Yes, she can stay with me.
And do you live alone in the apartment? Do you have children in the apartment?
No, just me and a dog.
Are you aware of your mom's mental health issues?
Yes. Yeah, I grew up with her.
And so are you willing to help her to try and stay on her medication so she can maintain a healthy mental state?
Yes. 100%.
And are you employed?
Yes, I'm self-employed.
Okay, all right. I have no further questions, Judge.
All right, any questions from the state?
No questions.
All right, and just one for me. Out of
sorry?
curiosity, what do you do?
Social media.
Okay. All right, so what, when you say social media, what are you?
Yeah, like basically influencer. Like I'm at probably like 10 to 20.
Okay, all right, thank you. Okay. All right, thank you so much.
Thank you. And I have no other witnesses, Judge.
All right,
Just
so,
argument.
all right, I'll hear your argument. Oh, you can come back up.
So Judge, I know Ms. Nutter did have some issues with her probation in the past. She's had probation before. But she's always, had the issue with being bipolar. That's never going to go away. And that's something where it's been a struggle for her. It's also cost her to do some things that are erratic. She's gotten into drugs. It seems like she's overcome the issue of drugs, but she's still been struggling with her mental health. And she did have a job before she was arrested. She was working with, I'll probably butcher his name, but Tim Height, the complainant. Tim was very generous, very helpful. He's a religious man, and he was helping her in giving her a job, giving her a place to stay, trying to get her, closer to God and away from drugs. He was interviewed by the state, and he himself feels that it's way too much to say it was a burglary of a habitation. He thinks that it probably should have been like a criminal trespass. He just wanted her gone because she was acting so crazy, so erratic, out of control. I think in page 5 of the report to the court, he's interviewed and kind of gives his thoughts on the matter, which is that he wants her to get the help she needs. He thinks she has a drug problem, but she is bipolar and she wasn't on her medication. So she either has to be getting her medication for bipolar, and in addition, if there's a drug issue, getting drug treatment. And my client's open to doing what she needs to do. She's just asking the court to have the opportunity to do that. She does have a place to go back to. Her daughter will let her stay with her. And I think that it's probably a better solution than putting her in TDC and at taxpayers' expense, when she can kind of try and get her affairs in order and still abide by the court's requirements. And if she doesn't, the court always has the opportunity to simply revoke her if she doesn't do what she's supposed to be doing.
State.
So for that reason, I would just say, I'm sorry. Yeah. Okay. For that reason, I would just say if you could give her probation. Thank
All
you.
right. Thank you. State?
Judge, just due to the previous history of repeat offending states in position that, in lieu of prison, leave a long probation, be appropriate in the case.
All right. So I will tell you, this is a very difficult case for me on deciding what to do because I don't have a crystal ball. So I'm weighing the fact that you've never successfully completed probation. I mean, the PSI I'm reviewing, you're given probation and each time you were revoked. You were revoked in 2008, and that was interference with child custody. And I'm assuming that's involving the 13-year-old.
That's involving this young lady that.
Oh, that's involving her, okay. And then there was the bail jumping in 2013. And I know, depending on what county you're in, when you don't show up, they'll charge you with bail jumping. And then the probation on that was revoked. And then everything else, it appears that you have taken time. So this is a difficult case. And then the complainant, I've read the PSI report, the complainant does not want you to go to prison. Complainant feels that you need help, that you have mental health issues and drug issues. Now, according to the TAP evaluation, they think that you're minimizing. So this is what I can tell you I will do. And at first I was strongly thinking about giving you 3 years in the prison and not granting your application. But if I grant your application for probation, you're going to remain in custody because they want to evaluate you for DDRF. And how long is DDRF?
Yeah, it's 120 to 180 days. Currently, there's a 10 to 12 week wait for females.
And I have no choice but DDRF for you because it appears that you have the mental health issues along with drug issues. I could refer you to felony drug court, but if felony drug court doesn't accept you, then it would be DDRF. So you can either, I can sentence you to 3 years in the prison. You'll receive credit for whatever time you've been in, or I grant your application. People will tell you probation in here is not easy. It's designed for the probationer that's before me. But if I grant you probation, then you're going to remain in custody. She's told you what the wait time is. That's the wait time. I have no control over that. So those are your two choices. If you would like to discuss it with your attorney, you can. All right. You're welcome. Y'all want to sit in the box and discuss? And then I'll bring you all back up. All right.
Well, Judge, actually, she's pretty clear on what she wants to do.
Yes.
That's fine with the waiting in jail, doing 180 days in jail.
All right. No, she's saying it's going to be 180 days. And then what else, Ms. Abrams?
So the program itself is 120 to 180, and the wait time is 10 to 12 weeks. That's after medical. Medical can take anywhere from 2 to 4 weeks.
So you're looking at the time in DDRF plus the wait time. You want to think about it a little bit?
Sure.
Okay. All right. Just let me know when you're ready.
Yes.
You're welcome.
Let's watch how Judge Boyd handles this one now.
Yes, we're back on the record and 2024 CR 011162. All right. Have you all had a chance to discuss your options?
We did, Judge.
And what are you requesting, Ms. Nutter?
3 years,
Prison?
yes.
All right. The court is finding you guilty. The court will sentence you to 3 years in the prison, give you credit for any time served. I'll request the therapeutic community for her. But you'll have to request it also. Do you understand?
No.
When you go there, you'll have to let them know that you would like to be in the therapeutic community. The therapeutic community doesn't increase the time that you're in the prison. It's just designed to help you, for example, for you with your mental health issues and any drug issues, okay? And there is a $2,000 fine, time and money to run concurrent. And there's to be no contact with Timothy Height, Haight, and Country, Kountry, Campground RV Park. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes,
Did you understand it and did you sign it?
yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your
All right, so we can go off the record. Here's the thing. At some point, you're going to be looking at a habitual offender status. And what that means is for certain felonies, if you're charged with it, your minimum is 25 years in the prison. You understand?
Yes, ma'am.
So you're going to have to do better. You're going to have to stay on your medications. When you're released from prison, if you can't find a place that can help you, you can always come back to the court. If I'm still here, I'll see if I can help you find a place. All right, good luck to you.
Thank you, Your Honor.
You're welcome. All right, that's it.
Thank you, Your Honor.
Thank you.
Now we have Mr. Davis facing charges after a normal routine traffic stop escalated into an evading arrest charge.
All right. Court is calling 2024 CR 5244 State versus Jordan Davis. Do I have parties announced for the record for the state? Defense?
Good afternoon, Judge. Alfonso Cabañas for Mr. Jordan Davis.
And are you Mr. Davis?
Yes, ma'am.
All right. You all had a bench trial with the court, and the court, after both parties had rested and closed, the court asked for an opportunity to view State's Exhibit 1 in its entirety. The court did have a chance to review State's Exhibit 1 in its entirety, so the court will hear closing arguments. State?
Your Honor, does the state typically not give closing arguments in trial following the defense?
If they want to. My understanding from speaking with you off the record that the defense didn't really want to do a closing. So that's why I was asking you for your closing.
Well, Your
But
Honor,
if that's,
I don't know whether defense counsel wanted to or not. But
all right,
my-
defense, do you want to get closing?
Yes, Your Honor.
Okay, then I'll hear your closing.
Thank you, Judge. Judge, as the court was aware during cross-examination a couple of days ago, the only officer that stopped Mr. Davis testified that the alleged traffic offense, that he saw being committed was not recorded. I asked him when I talked and described as to the reason for the stop, he initially said, well, his headlamps were turned off, or he didn't have the number of requisite headlamps as per the transportation code. When he confirmed on the stand that as per the transportation code, my client had more than two, he had three functioning headlamps, so much so that during the video, if the court recalls, the officer testifies that the headlamps in my client's car were working. Therefore, Judge, we have testimony from the officer that the alleged traffic offense of not having any functioning headlights is completely false. Secondly, Judge, after we move on from that point, the officer goes on a narrative in which he's trying to tell the court what the officer, would do in this situation. The transportation code and the penal code don't read that way. The transportation code and the penal code read that my client or the individual who is alleged to have been committing an evading offense needs to be clearly shown as evading law enforcement. If the court recalls from the video, during the entire length of the officer following my client doesn't speed, doesn't turn off his lights, does not drive in excess of the speed limit, does not drive under the speed limit, does not avoid traffic, does not flee from the officer. Additionally, my client goes so much as to take the extra step and notify the officer by turning on his hazard lights. The officer makes it a point to say that there were multiple shopping locations or shopping centers on the left side of the highway in which my client could have turned. Well, Judge, then I questioned the officer on Texas DPS, the driving manual, which states that when being followed by law enforcement, a driver has to stop, or rather must go to the right and stop in a place that's well lit and safe, not only for himself, but law enforcement behind him. So when I questioned the officer as to whether or not my client could have stopped on the right, being that it's a construction zone, being that there was nothing but grass and dirt and it was not lit, the officer said, well, I don't know, but I could have stopped it. As we proceed through the stop, or through the video, Your Honor, again, you continue to see that at no point in time did my client commit any additional traffic offenses other than the alleged traffic offense, which again was not recorded. The officer testified that my client was driving a vehicle that was not stolen. He was driving a vehicle with a seatbelt on. There was nothing that my client was doing as he was driving that warranted a traffic stop. As the officer continues to follow my client, with his hazard lights, turns to the right as he should, and then parks in an area where the officer testified there's no cars coming back and forth, thereby making it safe for my client and law enforcement to continue this interaction. And so the point of this, Your Honor, is that at no point in time did my client evade any arrest or detention. My client simply drove to find a place to stop. We know that he did not flee. We know that he didn't even intend to evade arrest or detention. He was simply looking for a safe place to stop. And as he was doing so, he notified the officer behind him by turning his hazard lights and maintaining a safe rate of speed. And for those reasons, Your Honor, I ask the court to find my client not guilty of the offense of evading arrest or detention.
All right, state.
Defense counsel's arguments are well made, but at certain points logically inconsistent and at other points irrelevant. Mr. Cabañas points out that the deputy's testimony was that Mr. Davis had 3 headlights on. Now, if Mr. Cabañas means this to mean that the high beams were on, then Mr. Davis committed an offense by having his high beams on within 300 feet of oncoming traffic, in which case Mr. Davis committed an offense of the transportation code.
Was there oncoming traffic?
There was, Your Honor. And
Okay.
we'll be able to see it from the officer's dash cam recording. So Deputy Enriquez did have reasonable suspicion to detain the vehicle. Moreover, case law is clear. Under Lopez v. State, the Court of Appeals for San Antonio stated that although the officers agreed that Lopez was not accelerating from them or driving recklessly after exiting the highway, fleeing is anything less than prompt compliance with an officer's direction to stop, and fleeing slowly is still fleeing. So the fact that Mr. Davis did not speed or travel under the speed limit, the fact that he did not weave in and out of traffic, the fact that he was wearing his seatbelt, these are all very interesting assertions, but they are not relevant to the court's determination of whether he evaded arrest or detention. Finally, there's been no evidence introduced that Mr. Davis was actually following the Texas DPS handbook. There's been no evidence introduced that he's ever read it. There's been no evidence introduced that he was even vaguely aware of it. And so Mr. Cabañas' reliance on this Texas DPS handbook is misplaced because there's no evidence that Mr. Davis was actually following its advice. Even if he were, there were multiple areas for Mr. Davis to stop. The area in which he stopped was not a well-lit place. Deputy Enriquez testified that after the vehicle came to a stop, other vehicles had to go around it. And it's because where Mr. Davis stopped was on a 2-lane road with no bike lane or improved shoulder for him to move into. And so the only place that he could stop was in the lane. So for those reasons, the court should find him guilty.
All right, so you're saying that there is no proof that he knew what was in the Texas driver's handbook, and therefore that should be disregarded? The officer's testimony with regards to the Texas driver's handbook?
The officer's testimony is not evidence that Mr. Davis.
No, that's what I'm saying. You're saying that there's no evidence that he knew about the rules for the Texas driver's handbook.
Correct.
And how is that relevant? Because the defense doesn't have to present any evidence, correct?
Correct. The defense does not need to present any evidence. But if the defense wants to rely on this DPS handbook for the proposition that Mr. Davis was obeying its advice, then there should be some evidence that he was at least aware of it, much less that he read it and that he obeyed it. And there's been no evidence.
All right. All right. The court has reviewed State's Exhibit number 1 in its entirety. I've heard both parties' argument. As both parties are aware, argument is not testimony, it's not the law, it's just your argument. After reviewing everything, listening to the testimony and seeing State's Exhibit number 1, the court will find the defendant not guilty. Is there anything else from either side?
Not from defense counsel.
Okay, thank you. If you will give this to the court reporter, please.
Yes, Your Honor.
Thank you for dressing appropriately for court.
Thank you, Your Honor. That's-
Finally, this last case centers on Mr. Bergen, who couldn't follow the rules of his probation and is now back in court facing the consequences.
All right, court is calling 2023 CR 10637 State versus Mr. Bergen Savala. Could I have parties announced for the record for the state?
Andrew Harris, Salem.
Ron Zimmerman for the defense.
And are you Mr. Bergen Savala?
Yes, Your Honor.
How do you pronounce your first name?
G.
Ranji?
Yes, ma'am.
Okay. All right. You have a motion to revoke and it's deferred adjudication. The defense is requesting a bond. You're entitled to a bond. Have parties agreed on a bond?
Have your honor.
And what amount is that?
That would be $7,500, Your Honor.
All right. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth, and nothing but the truth, so help you God? All right, you can lower your hand if you'll state your name for the record.
Bergen, Savala.
All right, Mr. Bergen Savala, I'm not going to ask you any questions about your motion to revoke or any questions about the case. The only thing I'm going to ask you questions about is so that I can determine whatever conditions will be appropriate for your bond. All right. So have you ever been diagnosed with any mental health issues? Ever been on any type of medications for any mental health issues?
No, Your Honor.
In the past, have you ever used any type of drugs? All right. And what would that be?
Marijuana.
And what else?
That's it.
All right. Any alleged gang affiliation? And if you were released on bond, where would you be? Well, who would you be staying with?
My mother and my sister.
And how old is your sister?
I have 3 of them. 21, 20, 21, 19, and 17.
Are there any children that are underage in the home?
Yes, my 21-year-old and 19-year-old have sisters. They each have a son apiece.
All right. And what is the child's age?
2 and 1.
Any concerns about him living in a location with children state? All right, then I'll follow your agreement. I'm going to set your bond at $7,500. There's to be regular UAs. And Ms. Ferguson, if you can set this in 2 weeks for a contested hearing, please. All right, you coming back on February 24th for a contested hearing. And if you'll make sure he has a reset form. All right, do you have any other questions? Anything else? Yes. Yes.
Mr. Bergen Savala has an unindicted PG 1-4 to 200, for which Meredith Chacon is the attorney of record. Would you please set that case on the same date so that we might try to resolve both cases simultaneously?
All right, Ms. Ferguson, if you'll set those both. Okay. All right, anything else?
Yes, Your Honor. I'm wondering if it might be more efficient for Ms. Chacon to be the attorney of record on the MTR as well, too, Your Honor.
I don't think so, because, and the reason why I say that, because she's not here and I've given you all a contested date and I want everybody to be ready on that date.
Okay.
All right, thank you.
All right. Thank you, Your Honor.
Thank you.